Mr. Shashank, at 6 o'clock, can we start the session? I have given you the option of yes, you could unmute yourself.
Am I audible?
Yes, sir.
So, very good evening, dear members of the bar,
I will have
respected
to
advocates.
introduce you and I will have to welcome you, sir. Just a second.
Sure.
Can we start the session?
Do you want me to proceed?
No. Can we start the session?
Sure, we can start the session. I'm all excited and ready to share information with the respected advocates.
Sure. Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Mr. Shashank Kumar, Advocate, High Court of Karnataka. Mr. Shashank, it's a pleasure to have you with us today. Welcome to the webinar. Now I would like to introduce our today's speaker. Mr. Shashank is a partner of India International Law Firm, a graduate from National Law University, Lucknow. During law school itself, Mr. Shashank started fighting for legal rights by filing RTIs and contesting consumer cases against mobile and courier companies for deficiency of service. He had undertaken several pro bono activities to save the environment. He believes that a lawyer knows the law and can help the society. He did his judicial clerkship with Justice Vikramjit Sen at the High Court of Karnataka and assisted his lordship then. He had also interned with Justice U.U. Lalit, Judge, Supreme Court of India, also with Mr. Harin Rawal, Additional Solicitor General. Apart from dealing with several areas of civil and criminal matters in India, he is also dealing with international criminal law cases, international commercial trade disputes, immigration laws, international matrimonial matters, etc. He regularly appears before the NCLT, National Stock Exchange, Company Law Board, various trial courts, High Court of Karnataka and Supreme Court of India. Mr. Shashank, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you.
Thank you so much for the kind words, Vikram. Good evening, dear members of the bar, respected advocates, viewers watching this knowledge sharing initiative by Advocates Association Bengaluru. I'm extremely honored to be here. Friends, 2020 has transformed the way we live and function. I mean, needless to say, the technology has become an integral part of our lives on a day-to-day basis. Today, we are forced to adopt technology in education with online schools, online businesses, and major decision-making. Everything is happening online. In fact, we are also discussing about virtual courts, which was unimaginable a decade ago. I believe the AAB has already done quite a few webinars on cyber crimes, IT intermediary, digital evidence, which are also available on YouTube to watch. On the agenda today, we will be understanding data privacy. Then we will go on to discuss about existing data protection laws, and subsequently the much debated, the proposed personal data protection bill. So friends, we have particularly chosen this topic, data protection, because it not just affects the young, not just affects the old, but it affects everybody regardless of who you are. If not you directly, your friends, your family, your grandchildren, everybody it would be affecting. Now, recently, I asked somebody, is your data safe? His response was, 2 GB per day ide, aamele data off aitu. So, saak namge agutte. But friends, we are not aware of what is this data we are talking about. This is not your internet data. We are talking about data, the information, the facts, which are stored in the form of images, videos, your audio, writings, anything in a digital form on a computer, or it could be also stored in an online cloud. Cloud is basically like a repository of data in the virtual world. You can't see it, but it is there. Now, what we are going to deal with today is a subset of this data called personal data, which is referring to your data of a natural person, which is your data, such as like your name, your date of birth, your physical attributes, your gender, and couple of these things combined. Now, all of us have a smartphone, smartwatch, smart laptops, and let us consider a few day-to-day examples of how we give out data. You, all of y'all would have probably used this Google voice search or Google search. You will say, okay, Google, find me the best Chinese restaurant nearby, or the best TV you want to buy. Now, along with knowing that what you want to buy, it is also recording your voice. And you have permitted this app to record, store your voice. And after a couple of years, the artificial intelligence learns the way you speak by saving all your notes for several years. Now, another example I will give you of your maps, Google Maps. So you might be thinking, I want to go from point A to point B. Only that time Google is using your location, but it is not true. On a day-to-day basis, you can go back and you can check your mobile. If you go to the privacy settings of your mobile, you will find, I can tell you of 27th September 2015, where were you? Because you will be aware of this, the Google will be aware of your location, and it has been saving this particular location because you have allowed it to save. Now, another instance I will tell you, like you might have clicked a selfie, and because of the geotagging location, it exactly knows where you are. And I'll give you a personal example. I had gone for a holiday to Hampi, and before I knew it, my mobile created an album, which and it was already uploaded online with the name called Happy Hampi. Now, at that time, these privacy settings keep changing, and you need to ensure that you monitor these privacy settings on a regular basis to understand what data is stored. And just imagine if an ignorant person is clicking a particular selfie. Now, somebody randomly searches on Google Images, it will automatically display your picture, whatever you have clicked, and it will be for the public. And I'm sure all of y'all sometimes at one point or the other, you might have thought that the phone is listening to you. You do feel that sometimes, like let's say I say that I want a pizza. Next thing I know, there is a message which has come from pizza companies or some other discount companies giving me some sort of discount. So my point of telling these kind of examples, my dear friends, is that your web search history, your browsing history, your download history, all of this is saved. And exactly the companies know what you want to buy, what you want to eat, where you have been thinking of traveling. And this helps these marketing companies to give you exactly what you want. But it, all of it comes at a cost. This data what we are talking about, the buyer of this data actually knows the exact emotional pulse of you. It actually knows your habits, your likes, your dislikes, basically knows your exact psychological data which is there. And when it starts knowing this, and the artificial intelligence starts building this particular data in this repository, it can also influence you in the way they want you to think. I mean, I think so far you might be still okay. But what if I told you an entire elections could be won on just on the basis of this data? We are talking about a situation in the United States. Allegedly, the Trump election campaign was entirely influenced by a set of population was actually influenced by using their data from Facebook. Cambridge Analytica, a company based in UK. If you people can also search and read up about it. So it was accused of getting this information from Facebook, which it used and provided such marketing ads to those people to influence them during the elections. It was a small population, but nonetheless, Mark Zuckerberg himself admitted to some of these flaws and playing with people's personal data. Another example, my friends, Brexit. Brexit referendum was pertaining to removal of UK from the European Union. Now, this Brexit also was apparently, they say Cambridge Analytica, this company, was analyzing data of several people even during this Brexit referendum. Now, in UK, it allowed an Indian person who is residing over there to also vote for this referendum, whether to be in the European Union or no. By virtue of you being from a Commonwealth country, it already influenced you that you can vote for this particular Brexit. Now, you might be thinking that, okay, how is this actually going to influence a particular person? Now, if somebody who has absolutely no knowledge about UK can easily get influenced by a simple ad. There are several such examples, my friends. Uber was accused in USA for allegedly leaking data to several persons. They had like the data was at threat, their driver's license, their phone numbers, and another company was also allegedly it has sold laptops which had inbuilt software which can send the customer information to third parties without you even knowing and without your consent. Now, there are most of us who are using these particular smartphones, our friends, families are all related to using these things, but nobody bothers to actually check privacy settings. I mean, to all the lawyers out there, if I give you an agreement and ask you to directly sign on the last page of the agreement, what would you say? You will call me crazy. But we are doing the same thing online. Now, without reading, we directly go to and click I agree, and we don't bother to read these terms and conditions. So one request, I think you can go back to your respective accounts, check your privacy settings after this session is over, go on to your social media platforms, your email, other website portals, shopping websites, wherever you are basically giving your data, even your mobile apps, go out and check out your privacy. You will be shocked. What you have been giving to these internet companies is gold. This data, my friends, is gold. It is $1 trillion industry which is thriving on you. Now, because there is another profession also, which is called data scientists, which specifically deal with data mining. They look out, dig out this particular data from you and sell these to particular companies for profit. Now, obviously, this particular data protection issue is not something which is new. It has already been in existence for quite some time. We have been debating, talking about this thing. Now, 2020 is going to be a momentous year for data protection legislations across the globe. And day in and day out, this topic has been churning a lot of attention. Soon there will be data protection legislation which will come in Brazil, in Thailand, in South Korea, who all want stricter data protection laws. In fact, California also had passed a California Consumer Privacy Act, which is pertaining to protecting data only with respect to residents of California. And it has certain civil penalties under that, which range from $2,500 to $7,500 on a per consumer basis. Now, all of this is actually a domino effect of the GDPR, which was basically passed by the European Union, which adopted this GDPR, which is full form is General Data Protection Regulations. So they had adopted this in the year 2018, which basically regulates the law on data privacy and data protection of the EU citizens primarily. So this is a brief glance about data privacy and how it has been taken into consideration across the globe. It is very much necessary for us that we give more attention to such kind of things, because there are several situations I can tell you, meaning there is, for example, a company in Ukraine which has a subsidiary company in India. It is taking our information and storing our information in another EU country, let's say Germany. Now there are multiple countries which are involved, and this data protection legislations, my dear friends, is very, very important, because this is where the future is lying. So it's not like India does not have any such legislation in existence. I would first like to discuss with you on the current data protection legislations, which is the Information Technology Act, and share a couple of important provisions under this act. First is Section 43A of the IT Act, which is pertaining to compensation for failure to protect data. So it basically states that when a body corporate is dealing or handling any sensitive data and is negligent in implementing and maintaining reasonable security practices and procedures, then by which it is causing wrongful loss or gain to any other person, then he shall be liable to pay damages by way of compensation to the person so affected. Now, this section particularly does not define damages or specify how much damages it should be there. Another section I will take you all through is Section 72, which speaks about penalty for breach of confidentiality and privacy. So any person who has secured access to any electronic record without the consent of that person, and he ends up disclosing this electronic record to any other person, he shall be punishable with imprisonment for 2 years and fine which shall extend up to 1 lakh rupees. Then there is Section 72A, which speaks about punishment for disclosure of information in breach of lawful contract. Now, any person, including an intermediary, who has secured access to material which is containing personal information with the intention, mind you friends, with the intention to cause or knowing that he will cause wrongful loss or gain, and without the consent he has disclosed this particular information, then there is punishment which may extend up to 3 years and fine up to 5 lakhs. So this is pertaining to IT Act. Apart from this, there are several other provisions which mostly dealing with hacking, or like there is Section 70B, which wherein your insert INCRT, which is your body, Indian Central Emergency Response Team, which can direct any body corporate or any data center to furnish this data. And if they don't furnish any data to them, they will be punished with 1 year imprisonment or 1 lakh fine, and so on and so forth. So this is just pertaining to the act. There is also information technology, reasonable security practices and procedures, and sensitive personal data or information rules 2011. Now this particular rules has defined what reasonable security practices according to it is. So it is trying to say that if you have this ISO 27001 as one of your policies in your security policy of the company, if, then you are okay. Then this is an international standard basically on how you manage your information security and how you're going to deal with data breach and data management. This is the existing law as such. Apart from this, the rules also define sensitive personal data. Now this sensitive data can mean your passwords, your bank related information, your physical, psychological, mental health condition, your sexual orientation, your medical records, your biometric information. Now all of this particular information altogether, the rules is defining this as sensitive personal data. There is only some obligations which have been raised under this rules, which is that the company will be publishing a privacy policy on their website, which will be clearly legible and easy to read for everybody. And it shall basically disclose regarding the types of data which you will be as a company which will be collecting, and the purpose why you're collecting this data and usage of this particular data. Now, rule 5 of this rules basically states that the body corporate shall obtain consent in writing or by email from the data of provider of data, which is you. Now, I have never heard of any company like the be it the Facebooks or any other local Zomatos or anybody that they have obtained consent in writing or by email. Most of the times, this consent is deemed consent. So the privacy policies are also drafted in such a manner that the moment you're using their service, you have consented to their particular privacy policy. But if you see this particular rule whole and whole, there is a clear violation of these particular rules. Now it is this particular rules also states that you shall not collect any personal data until and unless it is for any lawful purpose connected to that particular body corporate. Now, and it also obligates that once that work is over, that data is not going to be held back any longer, and they have to basically, it is just certain duties or obligations. There is no deterring factors in these particular rules. In fact, if you want to delete any data or you withdraw consent from any of these particular companies, there is an option for you not to provide that information or data, and you can withdraw this consent, which is also supposed to be in writing. I have never heard of any of this happening, but if it is happening, it is great that somebody is taking consent from a particular data provider in writing. Also, it speaks about appointing a grievance officer, which is similar to your IT intermediary rules, which also speaks about appointing a grievance officer. So in case you have any problem, you can go to that privacy policy. There will be one email ID which will be there, or phone number or something. You can call this person, and if this person doesn't address your particular grievance, there is a big question mark, which the act or the rules does not talk. It is very open to interpretation, basically. Now these particular rules, they've also told that you can transfer this information to any outside countries. Like that permission is currently also this rules is applicable. Okay, so please read up and understand these rules in details if you feel. So this rules basically, you can any body corporate or any person can transfer any information outside India, which to any other country, that ensures same level of data protection that is adhered by the body corporate. Now it also states that this transfer may be allowed only if it is necessary for performance of a lawful contract between these particular companies. Now, clearly, there has been a lot of lacking of implementation, giving way for companies to misuse our data. Even till today, this is the law as it stands as on date, and there are a lot of loopholes which the companies can take advantage of. Some big conglomerates, obviously, out of GDPR, which is your EU laws, they have these big MNCs are the ones voluntarily they have gone ahead and they will provide you an option. If you want to delete any data, you can go to their particular, the Google or the Facebook, you can just go to the privacy policy, you can just check out what are the information what you are sharing with them, and you can delete this particular data. But this is just few companies what I am talking about. There are so many companies which are day in and day out dealing with your data, which do not even have privacy policy, which are doing e-commerce businesses. And I myself have sent some legal notices some to an e-commerce company. And in fact, instead of having a privacy policy, they just settled with the client saying that, okay, we did a mistake, just forgive us, we are a startup. Okay, but because nobody actually wants to spend on this particular factor. But it will be a huge learning for our lawyers, because we are in Bangalore, where there are a lot of startups, lot of companies which are there on a day-to-day basis. And these companies are, you can provide policies to these companies, and these are the companies which you can give way to in future. And considering these particular flaws, basically the Justice Sri Krishna Committee recommended certain changes in the law, which came about in your Personal Data Protection Bill 2018, wherein there were certain amendments, changes which were made. And again, in December 2019, it was brought about before the parliament. And again, it has been sent back for certain changes. Now, as we can see it, there might not be too many changes as such. So I want to take this opportunity to brief you, dear advocates, regarding some of the salient features of this bill, so that you understand and are aware of what actually is happening if this bill is passed in this particular session. Now, what the bill defines is, there is one person called data principal, which is you, which is the natural person to whom the personal data is relating to. Another is the data fiduciary, who is collecting this particular data, which is any person, including the state, company, or any juristic entity, which is just collecting this particular data and processing your personal data, basically. So the bill basically also defines certain other things which is different from your sensitive personal data, which is defined in your 2011 rules. So it has also gone on to include your sex life, your sexual orientation, your genetic data, which is your DNA. Because I know that there is a DNA bill also which was proposed, which has not yet been passed. Because once that particular bill is passed, then what will happen, that your DNA, to every information of yours, whatever is there, will be given straight to these particular companies. And the central government obviously has powers to authorize any agency to deal with any of this data at any point in time. So, my dear friends, there are certain other features under this particular bill which is proposed. So, it is basically that every data fiduciary, which is the data collector, shall give a notice to the data principal, which is you. And at the time of collecting this particular personal data, apart from that, it states that you will not retain any personal data beyond a period necessary to satisfy the purpose for what it was collected, and then delete that personal data at the end of that particular purpose once it is completed. Now, what it says is this personal data shall not be processed except when free consent is given by the data principal. Now, this free consent, what we are talking about is the free consent under Section 14 of Indian Contract Act. So, they have to also disclose, okay, for what purpose they require this particular information, and how it is going to be used, to whom it is going to be given. All of this information has to be provided from the person who has been giving this particular data. Until and unless they disclose these particular facts, that to whom it is going to be given, and that particular or for what purpose they are collecting this particular data, that particular policy itself, the consent what they have obtained itself is going to be void. Now, the act also states that the burden of proof that the consent has been given is on the data fiduciary, because they are acting and they are holding a particular data, and rightly been done that the burden of proof is on that. Because I remember listening to one particular thing called consent uh, uh, consent fatigue. So it is basically even if you know that there is consent and like you have to sign this particular document, you have to read that. Even the best of best lawyers these days are just giving a go, I agree, and go. You install the app, you use the app however you want, basically. So this particular bill, basically coming back to it, okay, so it is giving certain other manner in which how your personal data can be, this is without consent, how it can be processed. Now, one is we spoke about with consent, wherein they can, you will have to give your consent clearly, and that burden of proof will be on the data fiduciary. Now, the other is without consent, they can obtain or use or process your personal data for the performance of any function of any of the state, or for compliance of any order or judgment of the court, or in cases of medical emergency, or to for the purpose of providing any medical treatment, like in cases of an outbreak of a disease of an or an epidemic, or generally for the sake of sovereignty of India, and in cases of any disaster or breakdown of any public order, they can process this personal data without your consent. And also in cases of any public interest, okay, so the bill clearly defines what it means according to them. The public interest, basically prevention or detection of any unlawful activity, including fraud, whistleblowing, etc., etc. Now, the bill also has certain unique features which we have not seen, and primarily this is influenced by your GDPR in the EU. So it speaks about personal data and sensitive personal data of children. So consider this particular situation where in a house, everybody is today's, even children are given special laptops because their classes are happening online. And so what this bill basically does is it puts an obligation on the particular data fiduciary to verify the age of that particular person and obtain the consent of his parent or guardian. Now, this data which is collected from children is clearly barred from profiling or tracking for the purposes of any targeted advertising on and or any purpose for which it feels that it is going to cause any significant harm to the child. This particular uh, this particular personal data cannot be collected by them. except there is an exception under that. It states that for the purpose of exclusive counseling or child protection services, they will not be required to obtain any consent of the parent or guardian, and wherein they can use this particular personal data of the children. Now, a very important chapter in this particular bill is the rights of the data principle, which is you. So, what is happening is that under this bill, you have the right to obtain information from the data fiduciary regarding how your data has been processed or whether it has been processed, and a brief summary of how they are processing this data, collecting this data. So you can anytime you can demand this from any of these apps or any of these websites or online entities. Now there is a right to data correction and erasure also, which is there, which is a concept which is also influenced by the GDPR. So it is pertaining to, if you have a particular information online, you can get that data corrected if you feel that any particulars are wrong. And in fact, you also have an option to erase that particular data, delete that data. So this right to be deleted is a right which has been for the first time, which has come in this bill, and it has to be considered. And if a data fiduciary receives a request from any person that he does not want a particular data, and if the data fiduciary is rejecting that particular data, because obviously they control your particular data, there is obligation which is imposed under the bill, which allows them to, they have to give you adequate justification for even rejecting such an application. Apart from that, there are certain other rights, which is you anytime you want, you can remove this personal data in any commonly used machine readable format. You can ask the data fiduciary to give this particular personal data in a structured manner. So this particular right is there. And after that, there is also right to restrict or prevent the continuing disclosure of personal data after it has served the purpose. And you can withdraw this consent at any point of time if it has not been withdrawn, and the data fiduciary continues to use your personal data. This can obviously be challenged before an adjudicating officer. Now, there are a couple of other important factors which I would like to take you all through, is that all these online entities will need to appoint an independent auditor, data auditor, not the CA auditor. This data auditor will audit and see how you have been maintaining this data with you, and how you have been using, whether you are following all the particular protocols. And this data auditor will also assign a rating in the form of a data trust score. And this is an obligation on the company that they need to appoint this data auditor. Now, apart from this, even if the central government or any authority appointed by it wants to direct any company or wants to audit any company, whether it is following certain guidelines or no, it has powers at any time. There have been search and seizure powers which have been given under this act. Anytime they can go to any company, they can pull out all the data and their computers, laptops, their records, to see whether there is any if they are following the guidelines under this particular act or bill. So this particular point, if you do not follow this, any data fiduciary, okay, which is not following this and fails to comply this, there is a penalty of 5,000 rupees per day, which is subject to a maximum of 10 lakh rupees. So this is pertaining to your rights under this particular bill. apart from this, the bill also talks about appointment of a data protection officer. Now, every company which is dealing with this kind of data shall have to appoint a data protection officer who will be based in India, who will be monitoring this particular personal data processing activities. So, and how the company is doing, and it will advise that particular company on fulfilling its obligations on personal data, etc. And so apart from this, there is also provision for grievance redressal by the data fiduciary. So if you want, you can file a complaint with the data protection officer, which has to be resolved within 30 days period. So this is a new designation which has come up in this particular act regarding a data protection officer, and every company has to comply with it. Otherwise, there are clear penalties which have been prescribed under this act. So there is another thing what I want to say is that there is restrictions which have been imposed under this bill for transfer of your personal data outside of India. So what it states is, if there is a sensitive personal data, then it shall be continued to stored only in India, which I have already explained the current law, and the difference in the proposed bill is that this sensitive personal data is going to be in India, and it shall be processed only in India. It also makes certain restrictions on the transfer of this particular data outside of India, except there is certain exceptions where they've got consent from the central government, or if there is any intra-group scheme or any contract as such, which allows you to transfer this particular data, and there is explicit consent which is obtained by the data principal, which is you, that you can transfer this data outside India, then it certainly gives you that gives them that particular right to transfer. Now, apart from this, there are certain penalties if they don't comply with any of these particular provisions. They can take prompt action, and they can, if you're in violation of any of these particular provisions what I have stated, then they will be punishable with a fine of rupees 15 crores, or 4% of the annual turnover of the annual turnover globally. Basically 4% of the annual turnover of this data fiduciary globally. So this particular amount can be a huge amount. So this is deterrent on these particular companies, that they audit their particular data through an independent data auditor. They maintain certain compliances to ensure that the data is not compromised. Otherwise, there are enough fines which have been prescribed under this act. Now, some of these things have been obviously been influenced from these global data protection laws, which I have illustrated earlier. So this is obviously going to be the first step which the government can take with respect to your personal data and your sensitive personal data. All the more because everybody is connected and everybody has an Aadhaar today, and there is also a provision under this particular act which speaks about social media intermediaries, which there is no clarity on that particular provision, which speaks about identifying or verifying a particular profile. Now, how they are going to do, we never know. There was a debate in between where they might ask for your Aadhaar, which I am not really sure, so I'm not making any comments on that. But what I can say, friends, is that today we understand that where we've gone with technology, and tomorrow it is going to bring us to a different level. In During this particular lockdown, in Delhi High Court, they had e-filing online system, wherein wherein even your evidences, your entire document, set of documents, you're scanning it and you're sending it to the particular registrar. Yeah, there is an option, you have to physically file it as well, but you're scanning it, you're putting a table of contents, you have like your page numbering and everything which is there in this particular high court. So what my thing is, now we are also in a way going to become a data fiduciary. Okay, the courts will become liable, and they will also have to understand that you are dealing with sensitive confidential information at each and every point of state. Apart from that, there is your surveillance of CCTV. I remember learning about this through some sources, that these CCTV, public CCTV cameras which will be there, are going to be used for automatic detection of a particular accused, and they will have this facial recognition system which automatically keeps scanning with the way this system is such that it can scan your particular face, and it can detect whether a criminal accused is there in a particular location, make it need easier. So you can imagine your entire data is going to be synced, and it is going to be synced with the state governments or any agencies or anything as such. So an interesting thing I wanted to share, even when I had gone to the Singapore Supreme Court, I noticed that their bar association also had a facial recognition system. So any bar member who wants to enter the bar, he has to basically, his face must be recognized with that software. Only then the door automatically opens. So friends, this transition in technology is going to come. Maybe all the thing we can do is that the law must keep pace with it, and our lawyers must continuously keep pace with it, and we have to catch up on this particular thing, and constantly initiatives must be taken up. This is my belief, to educate, share knowledge with everybody. So I really hope that I've tried to share a good amount of information in a very short span of time. uh, I believe that both the bar and the bench should take this particular thing of data protection very seriously, because in US you will find that $1 million suit which is filed, okay, for a simple thing, and now after this Consumer Protection Act 2019, which gives rise to your class action suits, there is all the more, there will be more and more suits which will be coming. Thing is, the bar and the bench should take this seriously. If there is $1 million suit which is filed in India, we have to be equally serious that it is your sovereignty, it is your integrity, everything which will be compromised, the country's security which is going to be compromised if there is any data breach. So this kind of deterring factors, if our courts and we as lawyers take it seriously, or when we are advising our clients, only then is we are going to have a strong democracy. So thank you, dear friends. Okay, I hope that I have tried to cover everything as such. Now back to you, Vikram.
Thank you, Mr. Shashank, for an intriguing and a very informative session. Yes, now we'll move on to the Q&A session. I see Lion wants to roar. Mr. Gupta, sir, is already ready. Sir, I have unmuted you. You may kindly pose your question.
Hello, Mr. Shashank, am I audible?
Yes, absolutely.
Okay, wonderful. You have taken a lot of pains to present the matter. See, you are talking about the technology. Now the technology is very much suited to the younger generation. generation like us who have put more than 50 years of practice in the bar. I have to take the assistance of my daughter. I have to take my grandson to open the system. How we have to cooperate? Tell me. Then that's the question. Next, see, technology is developing like anything. We have to. You are rightly said. We have to cope up with the technology. Now you say you are talking about the present law and the future law. Our legislators, they don't understand this. They are busy otherwise, and they don't know this technology also. We are allowing them to legislate the law on this particular case. How do you overcome this, Mr. Shashank?
Thank you for your question, sir.
Because protocols, parameters, and everything is there. Safety of the country is there. Safety of the information, personal information, everything is there. Because we are not going so fast to meet all the challenges of law.
Absolutely. Your comment is absolutely correct. And we as youngsters are also worried about this because by birth, you see these days, they have profiles, Facebook profiles by birth, and everybody is using on a day-to-day basis. But with respect to your question, sir, how your age group can catch up is that one thing is that the younger generation should be allowed to come up to this older generation, and there has to be a mix. Now, sir, don't get me wrong, but we want the bar members as well, okay, to appreciate the younger generation. There might be, we have lot to learn from the older generation, but yes, when you see the younger generation, their understanding of technology is there. Okay, we can help out in changing certain procedures and easing out certain factors. You will believe it or not, I'm sure you are also comfortable maybe arguing from the house right now than because of the pandemic, because of the reason of security and safety. So it's what they say is practice is never dies, because until our life ends, we are continuously going to practice. I think this is a part of our practice that we try and adopt to this newer technologies. Trust me, sir, the world is also doing it. I'm sure you will be faster than us in no time.
Shashank, we should have cultivate the good habits. The good habits, HABIT. You remove H, a bit will be there. Remove A, bit will be there. You remove B, it will be there. Therefore, we have to have a good habits. As a elderly gentleman, I say, I am prepared to learn. Knowledge is power. Every day I have to learn. I have to learn from everybody. I have to learn from the junior members. I have to learn from my client also. They are also teaching us. We can't learn everything in the law college.
If we remove HAB, IT will always be there.
Yes, it is
tomorrow,
there.
it is always going to be there. So only thing is we have to adopt and adapt to this particular situation, learn from this situation. Sir, not just you, your children might be sometimes using these particular softwares without having any idea of the consequences of what is happening. So this is particularly only a knowledge sharing session that everybody should be aware of what is this privacy policies and how important and how this data can be used or misused.
Yes, they must come up with immediately the legislation so
Absolutely.
that it will cover. They are taking their own sweet time.
Yes, sir. Yes, sir. Absolutely, I agree with you.
Thank you, Divikram, for your wonderful opportunity given to me. I think I have roared.
Yes, as always. Before we take up next online question, we have one offline question by Advocate Lavanya. He has a three-folded questions. In fact, the first one is some clarity on quick wrap agreements and how it impacts a user. Would you like to share your views, or do you want me to complete all the three sets of questions and then proceed?
I'm not sure what you're speaking with when you speak about quick wrap agreements. So I wouldn't comment on that particular thing, but I think I can take any other questions as such.
Yeah, definitely.
I'm sure
Our
it is.
privacy policy and terms of use together form an airtight compartment for companies.
Sorry, can you come again?
I repeat, our privacy policy and terms of use together form an airtight compartment for companies.
Airtight compartment is probably not the word, but I would say that it is forming a lawful contract. And the courts have already interpreted this and said that if you are agreeing to a particular terms of service, and that particular terms of service forms, and you understand that particular services, only then you have entered into this. So it is going to be a lawful contract.
So she has clarified that what quick wrap means is those we click I agree ones on the website. So what it means according to her is, the what we tick at the end of the
Got it.
you know
Click wrap. Click wrap.
quick. I think that should have been click wrap. It has been perhaps it is a typographical error. It
Typography.
says that quick wrap. So I
Certain
had it to read out in the same way.
certainly these agreements are the courts have held it to be valid in law, uh, because see, although you see, I told under the current law they have to take written consent. Um as per the Indian law, maybe that can be one of the arguments that this consent was never obtained through writing. But as you see it, where this particular provision of law was never probably pointed out to the courts in certain cases in Delhi High Court and in Bombay, they have held it to be valid.
Right. Thank you so much. We have Ms. Vidya MN who has a question. I have unmuted you, ma'am. You may kindly pose your question.
Thank you so much, sir. Thank you so much for a wonderful session. It's a very good session. We have acknowledged many more informations on that. And sir, actually, my opinion, my question is on with regard to the bill itself. As the bill, it's presently which is before the parliament. Actually, it is. I think it is to some extent. It is silent about data localization and data globalization and the privatization also. So when it comes to India, sir, because as we feel that is we are actually by referring to the EU GDPR Act, so to some extent we have given a kind of the starting point on with regard to the enforcement of the legislation. But still, when it comes to the bill, I hope actually certain things are certain loopholes is there, as I mentioned now, with regard to data localization and data globalization. This is the first one, sir. And coming on to the other thing, actually in India, apart from IT Act and apart from the sensitive, the personal data rules, at the same time, simultaneously, we have the sectoral laws also. For example, maybe Telecom Regulations Act. It may be the medical, on the other hand, we have the information technology also. My question is that actually, like, what's your opinion on this? How the bill can be rectified? These kind of things can it be revised? Because I think you stated a one thing that is we are not having much change from Krishna Iyer, Justice Krishna Iyer Committee, that is 2018, what he's proposed and what the bill is pending before the parliament. We are not having much changes into that. And this is actually my a kind of a question, sir. What's your opinion on this?
So, madam, thank you, Vidya. Okay, madam, see, I'll just tell you a couple of things. I had spoken regarding this when you speak about data localization. There is an entire chapter which states where restricts a company on transfer of these personal data outside India. I mean, this was criticized because GDPR or other countries do not have this particular thing. And they have clearly told when it comes to sensitive personal data, it explicit consent will have to be obtained. Otherwise, it cannot be transferred or sent outside India without the permission of the central government. Now, this sensitive personal data can be stored and processed only in India, and that itself means your data localization. And coming to your second part of the question where you spoke about alternate acts which are there, like your medical and other related acts. See, the definition of sensitive personal data is such that it is talking about your health data. There is a definition clearly to cover up these particular definitions. See, I'm not saying it is perfect. I'm just telling that this is the first step which the government has to take. And as Lion sir was already saying, that we need to do it and do it fast. This is the first step. This is going to happen. And I'm sure there will be a lot of back and forth like every other law. But your personal data is the utmost priority at this particular juncture, when we understand that we were dealing with Chinese apps, and it became a huge hue and cry some time back. So it must be taken very seriously. And trust me, to some extent, they have tried to cover most of these particular sensitive data, including your biometrics, your genetics, your DNA, your sexual orientation, your sex life. Everything is tried to be covered. And in fact, they have also covered your religious belief under that particular bill. So I think that it will be a first step. Maybe even if we call it a baby step, it has to be the first step, and it has to be done soon.
Thank you, sir. Thank you so much.
Thank you, Mr. Shashank. The next question is, what is all about dark web or net web?
Okay, so dark web is basically a virtual world where the authorities or the police are still not able to catch up with that particular side, or of this particular people who are using it. I won't term them as hackers. Okay, they are particular developers. They know how these things are working. They find loopholes, and our cyber police is not very well aware about how to go about dealing with such things. And I myself, when I filed certain cyber complaints, the police is actually struggling. In fact, they had taken, some police officers are taking special courses in NLS, trying to understand what these cyber laws are. But more than understanding cyber laws, we need more techies to be a part of this police force. And these people are these young people who are developers, who know how to hack anything, how to go behind the way and find loopholes. So this particular protective mechanism does not exist in India, and does not exist in any forum whatsoever. I'm not going to comment on the agencies which have collected this particular data, sensitive data from us, and hold this particular sensitive data. It is their obligation and liability to maintain this particular data. So they need to have something called, in Infosys and other companies, they have hackathons where they invite developers. They tell you, crack it and show. So this gives basically an opportunity to protect your particular data. Now, dark web has several things, like from drugs, guns. Okay, several things have been traded. Okay, on that particular portal. You and I will not know about this, but the techies and the people who are actually in the IT business, okay, they are the ones who are very well aware of this. And there needs to be a merging of both these particular sections of or professions, so that they can ultimately give out the best to protect the security and integrity of the country.
Thank you so much, Mr. Shashank. I think Mr. Mallikarjun from Chitradurga has a question. I'm unmuting you. Yes, you may please proceed with your question, sir.
Very good evening, sir.
Good evening.
knowledge-based sessions. My question is, sir, when we have downloaded certain applications from Play Store or something else, always, as you said, that we have to agree the terms and conditions, which is, we are knowingly or unknowingly, we are just give the yes mark and we will agree the agreement. Okay. So this is an agreement between the application developer and the end consumer. Suppose as we are how to terminate that agreement. Suppose we are deleting that application from the Android or an iPhone. Does it mean to say that it is the termination of agreement, or it is still workful for the developer, or how we have to terminate that agreement?
Mr. Malikarjun, very good question there, and I think that is the entire point of our discussion. That this right to delete has not been provided in the previous laws. Although some companies, like you can go to your Google, you can go to your Facebook, you can go to the privacy settings, you can check it out. Initially, they will ask, you will click I agree, you will go to the next step. But actually, you go back, go to your profile. In your profile, there will be one general settings or some privacy or something. You can go and see what information you can share or not share. In fact, even when you're downloading some games or something like that, even that time there is once you download, you are obviously sharing it, but you also have an option not to download, not to download, and there is also an option where there is lesser information what you can share. So ultimately the solution lies only with the newer bill. If it becomes into an act where we get this kind of opportunity that I don't want anybody to know. Now if I know all information about you, we don't even know each other, and I know everything about you, you will get freaked out to some extent that how does this person know, so, which is very wrong in its way. And this is mostly an awareness sort of thing that we should ensure that we educate our brothers and sisters in the society that what is actually happening and how you can protect. I'm sure I will tell you a fact that 6 years back when I tried to delete my data from Google was prohibiting me from deleting my data. But subsequently, after GDPR, now you can go all your web search history, your Google Map history, everything can be controlled by you. You can delete it, you can pause it. Your voice search history, all your voice recordings are also recorded in that. So this is something, this obligation is on obviously on you. You have to take care of your personal data and ensure that every few months that you go back and see this particular privacy settings and see what is shared, and if it is something which you are sharing which you think there is a risk, so please don't share that particular thing or don't use that particular app. That is my request.
Thank you, sir. We have Mr. Jagrat who has a question. Yes, I am unmuting you, sir. You may quickly pose your question. Yes. Sir, you are not audible. You may quickly pose your question. Mr. Jagrat, you are not muted. You are unmuted, but we are not able to hear you. Meanwhile, we have Mr. Chandrasekhar who has a question. Yes, I have unmuted you, sir. You may quickly ask your question.
Good evening, Shashank.
Yes, sir.
See, I have come across that many a time the government agencies themselves share the data to the private persons. Instance is that recently I had an opportunity to fill up a form to CET, NEET as well as JEE websites, and I don't know how they get my data, and all unnecessary calls I am receiving from them. Is not the whether still the government agencies being responsible to protect the data, uh, was it not proper on them to not to share to the private persons?
Thank you, Mr. Chandrasekhar. Okay, this particular question, obviously the opposition in the parliament is also talking about it, that when your data is stored with the government, and obviously they have powers even under their bill, okay, they can, for the purposes of national security and so on and so forth, they can use your particular data in a manner which they feel fit without your consent. So I had already told with respect to, let's say, performance of any function of the state, or in case of medical emergency, or in case of is there any order or something like that. But obviously, because the act gives us the bill gives us the power that we have the right to delete, we should exercise that. Even under the current rules, there is an option to discontinue your consent, which is stated that you have to give it in writing. Okay, so I don't think anybody has even exercised that rule till date, but I think that it is high time that we take this personal data sharing very seriously, and to know how much you have to share.
Absolutely. Thank you. Mr. Jagrat, I'm unmuting you now. You may ask your question.
I'm audible now, sir?
You're
Yes,
not audible.
little. You can
Sir?
speak a little louder.
Now, sir?
Yes, yes.
Yeah. See, my simple question is, see, early in the morning, many people will get, you can also come across with, you got $1 lakh in a lottery, something like that. See, many people are responding to that type of messages, and they have taken bank balances. What is the protection under the act that kind of for that kind of cheaters?
Mr. Jagrat, see, I'll tell you a very interesting thing. This is very common. If you go to the cyber police, there is a list of offenses which are given over there, like your visa fraud, this Nigerian fraud, email fraud, bank fraud. There's a list. Okay, and per year they are registering more than 50,000 FIRs. These are FIRs which are people who have actually come down to the police station, taken the trouble of registering it. And trust me, charge sheets have still not been filed in half of them. Maybe 90% of them, there is no charge sheet filed. There is another set of population which is obviously, which is not taken care of, even coming forward and filing an FIR. They just leave it and they say, okay, it's a loss, let us just leave it. What the police will tell you is that when you got this particular message, you yourself gave your bank information, correct? So they will try and blame you first. I have noticed this personally myself, that they try to blame you. I mean, there are messages, that's why, from SBI and other banks which state that you should not disclose. But I'm not saying that our information, even with banks, is safe. Security is a major threat. I mean, if without OTP, your amount can be wiped out from your bank account, then you can understand what kind of security we have. And I mean, even RBI is not able to answer these things. You can file several complaints with the banking ombudsman, or you can file writ petitions also. But the relief is ultimately RBI, which is the apex bank. Okay, it has to take charge over these kind of banking frauds which are happening. And there is a separate segment, Mr. Jagrat, regarding cyber crimes, which has been dealt by another advocate. So I request you to go and have a look at that, which also deals with different kinds of crimes which are there. Certainly there is a provision under IT Act, and there is a way to prosecute them. So I just request you to just see that.
So it's not just about the laws, but being responsible, not sharing your vital information with any outsider. That is also, we have to be more responsible, and as advocates, we will have to advise our clients as well. Is that right, Mr. Shashank?
Absolutely. Absolutely. The two-way thing, two-way communication, and we have both responsibility as advocates. And in future, our courts also might become virtual courts. Oh, I want to point out a very interesting a fact over here. In Panama, there was one particular scam. Panama, I think everybody knows about this. Okay, which had leaked out several information about financial information about several persons, companies, including some people from India as well, like this in this Panama papers. So one interesting thing is they say allegedly say that it the entire information came out via a law firm based in Panama. So they were not responsible to keep your data safe. So one thing is when our seniors are telling that keep your file properly, okay, and maintain your file, keep the records properly. Okay, if even one paper goes from here to there, your senior will definitely shout at you. Similarly, that responsibility will start coming online. Okay, you have to do it. Tomorrow, your juniors will have to do it. We have to be more organized. We have to ensure that we keep this particular data safe, because we are dealing with our clients' data as well, which is confidential information between an attorney and a client. So with this, I think we can wind up the session, right, Vikram? Over
Absolutely.
to you.
Mr. Shashank, thank you so much on behalf of Advocates Association Bengaluru for this very informative presentation. With this, we'll be concluding today's session, and with your permission, we'll be now logging off today's session.
Thank you.
Thank you.